Hello and welcome to Mayor Brown's Protecting AI Inventions Through IP and Contracts webinar. My name is Brian Nolan. I'm an intellectual property partner at Mayor Brown. I focus on patents and trade secret matters, representing clients in all types of technologies, ranging from life sciences to high tech to consumer goods. I am pleased to be joined today by Lori Recker and Allison Avicki. Lori is the head of global business operations at Aetion Inc. She also served as general counsel at Aetion. Lori's experience has afforded her the opportunity to confront AI issues from both a business and legal perspective. This allows Lori to provide unique insights to the issues that we are addressing during this webinar. Allison is an intellectual property partner at Mayor Brown, concentrating her practice on litigating copyright, trademark, trade dress, and trade secret disputes in courts across the country, both at the trial and appellate level. Today's discussion will focus on methods for protecting AI through intellectual property, such as patents, copyrights, and trade secrets, as well as discussing key aspects of contracting involving AI. We will seek to address the benefits and drawbacks unique to these methods. Before we begin, I'd like to make a few housekeeping announcements. If you have any questions during the presentation, I invite you to let us know via the chat feature. Simply type your question and we will do our best to address the question. If not addressed by the speaker at the time presented, I will keep track of those questions and the panel will attempt to address the questions near the end of the webinar. Regarding CLE credit, we will provide an alphanumeric code during the presentation. In order to receive CLE credit, participants must record this code and return the CLE form within 10 days of the event to cle-events@mayorbrown.com. These instructions are also on the form you should have received. Now I will turn it over to my colleague, Allison, to begin the presentation.
Thanks, Brian. I want to extend a very warm welcome to those joining us. We not only have an incredible number of folks signed up here, but also you are all representing an incredible range of different industries, as well as roles within those industries. So sincerely, thank you for your time. We, to Brian's point, mean this to be an iterative conversation, both in terms of your questions today, which we hope to get to all of, but also in terms of making it a going forward conversation. And toward that end, I thought to mention, this is a very US-oriented discussion in large part. If there are particular jurisdictions that you live and work in outside the US that are of interest, we are happy to pick up the conversation with you directly. In addition to that, if there are sector-specific discussions worth having on your end that you'd like to pick up, we invite you to please be in touch. And one example, we have partners who are delivering virtual CLEs for folks in the insurance industry. So if something like that is of interest, we mean this to be a going forward conversation. To facilitate that, you'll see on this slide some definitions that we've offered for purposes of today, including the definition of artificial intelligence as borrowed from the Columbia University School of Engineering. Now, as I mentioned this, I smile because yesterday, the PTO hosted a listening session on AI issues. I know Brian's going to touch on it in brief, at least later, but one of the points in the conversation yesterday that came out before the PTO and was covered in Law 360 this morning, as folks might have seen, was that contributors were flagging some of the definitional issues involved with AI for purposes of patentability. So we put these slides forward, but there's certainly more that could be discussed on them. I do suspect that at least at a high level, these definitions will look familiar to many, and that's because while the use and significance of AI is exploding these days, the concepts and the terms themselves have been with us for some decades. So if we could turn to the next slide, we're going to, before getting into the particular legal regimes, just map out some of the components that we'll mention and will be underlying the discussion today. The first are algorithms, the codes and rules by which the AI operates. We distinguish that for our purposes from the model, the output of the machine learning algorithm. And then we are also going to be touching on data sets. Now, I'm sure that for anyone listening, depending on what industry you're in, you're already having flashing to your mind what data sets look like in your world. At a high level, we're really talking about data used for purposes of machine learning training. Data is also useful and applicable here for purposes of feedback loops in terms of validation and testing. And finally, we're going to discuss results or the output of models. So next slide, please. And as Brian mentioned, these are the top legal regimes we're going to be discussing today. With that, I am very happy to kick it over to our wonderful friend and expert in this space, Lori Recker.
Thank you, Allison. So we can go to the next slide. And for each of the 4 protection schemes that Allison just touched on that we'll be discussing today, we're going to start by asking what components of AI can this form of protection in fact protect, and against what? And we're starting with patents. And as you can see here, we view patents as being able to protect algorithms, models, and data structures, as well as results. So with algorithms, models, data structures, we're talking about potentially patentable material if the application transforms the device by enabling improvements in the process or the function of the computer. For results, certain results, for example, a new composition, device, method, or process, patenting may offer the strongest protection. And in the following slides, Brian is going to go into detail about what some of these things mean and how that protection works in practice. How can patents be used? Well, these patents protect the use of patented AI components against any third party or use by any third party. That's how they can be used. So with that, I will turn it over to Brian to tell us more.
Thank you, Allison and Lori, for that introduction. And if we could just go to the next slide as we have. So most of this discussion regarding patent issues in AI has focused on the question of whether AI can be named an inventor. This question has arisen in several jurisdictions, including in the United States, the United Kingdom, the EPO, and Australia. These jurisdictions have concluded that their current statutes limit inventors to natural persons. That was the conclusion of the United States Patent and Trademark Office and the United States Court of Appeals for the Federal Circuit in Thayer versus Vidal. That will remain the law of the land in the United States for now, because on Monday, the Supreme Court denied Thayer's request that it review the Federal Circuit's decision. Some jurisdictions have been more open to AI as an inventor. For example, South Africa and Saudi Arabia have allowed AI to be listed as an inventor. The inability to name AI as an inventor causes difficulty to arise when the AI provides a contribution that, if provided by a natural person, would meet the level of joint inventorship. The USPTO is confronting this question and seeking to promulgate rules that deal with this circumstance. As Allison had mentioned, it just held a listening session yesterday to obtain input from the industry on how to address AI and heard a wide range of views on the implications of AI and inventorship. Please go to the next slide. Many IP specialists agree that AI is not presently capable of conceiving of an invention and reducing that invention to practice without some human involvement. This allows a company to look to the contributions of the natural persons involved in AI to identify the inventors. Therefore, companies should have policies in place that track the persons that are identifying the goals of the AI system, designing the AI system, generating the algorithms, compiling the data sets that train the model, testing the results, of the AI output and implementing those results into products. With that information available, companies should identify a nexus between the person's contribution to the AI components or results and the claims presented in the patent. That will allow the company to identify the natural persons to include as inventors. At bottom, the goal is to make a good faith effort to determine inventorship. If we can move to the next slide. AI inventorship determinations run into some of the same issues that we often see in collaborations. Considering that AI projects often require input from different companies with different expertise. For example, a company that has developed an algorithm may partner with a company in a different field that provides specific data that company has collected or has expertise with. An example may be a technology company partnering with a life sciences company that has data on different disease states or structural function relationships between how certain proteins or molecules may interact in vivo. Not surprisingly, companies in different industries have different views on what contributions will rise to the level of inventorship. For example, some life sciences companies have explained that generating the initial algorithm or model is too far removed from the AI results when you consider the amount of data that a life sciences company provides to further train the model and the human intervention that is required to parse through the AI results to identify successful treatments. Thus, the initial activities may be insufficient to support an argument that the developers of the algorithm or the model contributed to the conception and reduction of practice or reduction of practice in a manner that would allow them to be considered inventors. But in some instances, employees from different companies will contribute to the conception or reduction of practice in a manner that justifies those employees being named as joint inventors. Each of those inventors, or more likely their companies, would have the ability to exploit the inventions in the patents, including licensing the patent rights. Now, this may be difficult to monetize the patent to the full extent if you haven't clearly delineated the patent rights that come from this. And Lori will touch on this a little later when she talks about key contractual terms. If an entity that is involved in AI development efforts thinks its employee contributed to the patent but was not named as an inventor, then the entity can seek to have a court add the employee as an inventor. And clearly we have this ability in the United States District Courts. If that occurs, the company will likely obtain rights in the patent through the employee's assignment and obligations if the court was to add the inventor or the employee as an inventor. We saw this, although not in an AI context, but in the recent case in Dana-Farber v. Ono, in which Dana-Farber sought to have certain of its scientists added to patents that had resulted from work that involved both scientists at Ono and scientists at Dana-Farber. Now, finally, we'd like to leave you, before we move off inventorship, with some practical issues that may arise if we determine that AI can be an inventor. One question would be, how does an AI system comply with the duty of candor to disclose all relevant prior art as that we have in the United States when it arguably knows all prior art? And more interesting for some of us that have to deal with litigations and depositions and presenting trials, I doubt any of us are really keenly looking forward to trying to take the deposition of an AI inventor. But even more problematic, oftentimes when we go to trial and we like to present the inventor and show the spark of genius that the inventor came up with that justified the invention, that may be lacking in the instance where all we can say is the system looked at a tremendous amount of data and produced the following results. Now, in that instance, you can talk about the difficulty in creating the system, but you may lose some of the human component that we often like to do when we're telling the invention story at trial. We can go to the next slide. I'd like to move on to patent eligible subject matter, which is always something that we have to consider in this type of art. So 35 U.S.C. 101 identifies patent eligible subject matter as encompassing any new and useful process, machine, manufacture, or composition of matter or improvements thereof. A claim covering AI may be susceptible to assertion that the claim encompasses patent ineligible subject matter, which has been defined as a law of nature, a natural phenomena, or an abstract idea, the last of which is most relevant to AI. An AI claim may require an assessment under the prevailing patent eligibility test, two-part test. First, you are asked, are the claims directed to one of the ineligible concepts we just identified? And if so, then you ask whether the requirements of the claim transform it into patent eligible protection. AI claims often focus on improvements in the AI architecture, computational techniques, hardware components, and the results of the AI. Many of these will not confront 101 challenges, but to avoid a patent eligibility rejection, it is good practice for an applicant to direct claims towards how the AI is integrated into the system architecture, the source of the data and how it's used by the AI system, and how the use of the AI improves the operation of the system compared to existing systems. While patent eligibility analysis can be difficult in certain cases, we have some guidance from the Federal Circuit on cases that dealt with computer applications where the Federal Circuit held that the claims recited a patent eligible subject matter. These examples include the EnFish case, where the claims focused on self-referential databases that the Federal Circuit held was patent eligible because it improved the computer's functionality. In Thales v. VisionX, we were dealing with inertia tracking systems for tracking motions of one object relative to a moving frame. Now, these claims use mathematical computations, but they covered a specific application that reduced error as compared to conventional methods. This identification of how the claim system reduced errors was compelling to the Federal Circuit. And an MCRO focused on methods for automating animated lip synchronization and facial expressions. And the court held the claims were patent eligible because they used unconventional rules related to various inputs. Thus, they were not directed towards an abstract idea. Again, these are just examples that you could look at to kind of frame the patent eligibility issues. If we could move to the next slide. So, as we all may know, the U.S. patent statute requires that the applicant distinctly claim the invention, and that's found in 35 U.S.C. 112b. And so meeting this requirement may be difficult if the applicant does not have a full clarity on how the trained model is operating. So it may be very difficult to define your claim distinctly if you're not exactly sure how the model is producing the results or how the model is working. Separate from the difficulty in describing the patent distinctly is there's just some practical considerations. There's always a balance between providing sufficient detail in the claim to allow a patentee to show that it is distinctly claimed and it meets the eligibility standards that we just went through, for example, by improving the functioning of the computer, while obtaining a claim that provides sufficient breadth to encompass the full extent of the AI invention. This tension in how an applicant drafts the claim may result in a patentee not having the ability to assert the claim against its competitor AI product because they are too narrowly crafted. The ability to assert the AI claim is further exacerbated by the limited insight that a patentee may have to how a competitor's AI is operating, because if you don't understand how your AI is actually operating, it may be difficult to understand precisely how a competitive product is operating. So the 112 paragraph 2 or paragraph B now may be difficult to meet and to move forward with. If we can go to the next slide. In addition to the distinctiveness aspect that we see in 112B, 112A has its own requirements. And again, the ambiguity around how the trained model operates may present issues in meeting the requirements of 112A. These are the enablement and written description requirements. Enablement requires that the specification provides sufficient information so a person of ordinary skill in the art can practice the invention without undue experimentation. Written description requires the specification show that the inventors possess the full scope of the invention. These standards may be particularly difficult to satisfy for claims that are defined functionally, for example, by the results achieved, as opposed to by some structural aspect of the AI system or the device itself. In the enablement setting, this is a concept that the United States Supreme Court is presently grappling with for claims directed to antibodies that are defined by how those antibodies bind to a specific protein. That is the Amgen v. Sanofi case. Now, while Amgen is a biotech case, the court's decision is likely to affect how high-tech and AI patent claims are considered, particularly if an AI claim seeks broadly to encompass all results of an AI system can generate, irrespective of what AI is used and how the AI operates to obtain those results. A claim like that maybe have to be reconsidered once we understand how the Supreme Court views the enablement requirement. To best position an application to comply with the enablement and written description requirements, an application should consider providing the algorithm that forms the basis of the AI, describing the model architecture, defining the training data set and how it was used to train the AI, explaining how the AI data correlates with data and results from non-AI sources, providing examples of how the AI achieved its results, and identifying those results. With this support in the specification, the applicant needs to present claims of varying breadth to provide protection against arguments that the claim scope exceeds the disclosure of the specification. So in that instance, you may want to have claims of varying breadth to make sure that your narrower claims that are very specific to your system are enabled and supported, and then expand out from there in hopes of gathering or collecting a broader range of what your competitors may be trying to do. And if we can move to the final slide that I'm going to talk about on patents. And we're going to focus on the obviousness framework in the United States. So we need to consider how AI will affect how we assess obviousness. Much of the public discussion to date has focused on whether AI can be an inventor. But AI's impact on how we assess obviousness may be the most difficult hurdle we confront. In the United States, the obviousness analysis asks whether the identified references teach each of the claimed limitations and whether there existed a motivation to combine the references with a reasonable expectation of achieving the claimed invention. In applying this test, we first define the person of ordinary skill in the art. The first hurdle that AI presents is whether this concept is still relevant in the instance where AI was involved in generating the invention. Traditionally, once we understand the skill level of a person of ordinary skill in the art, we assume that this hypothetical person has access to the relevant prior art. Again, how should we apply this concept with an AI system that may not only have access to the relevant prior art, however that may be defined, but have access to all prior art or prior art information? When we consider the other aspects of the obviousness analysis, AI does not have the limited resources of a human inventor. The limitations on a natural person requires an inventor to identify a motivation to undertake a combination and presumably some reasonable expectation of success for the inventor to expend the effort to make that combination. Conceptually, an AI system can consider all combinations, irrespective of the need of a motivation to combine. and should be able to predict the results of each combination as opposed to limiting its assessment to only those combinations for which a reasonable expectation exists. So separate from that, just calling into question the current methodology that we use, it can also disturb or disrupt other analyses that we make. For example, does the ability for AI to consider all combinations negate the concept of teaching away that we have in the United States, that you looked at something in the prior art that would suggest you wouldn't make this combination? Is that a relevant inquiry if you have a combination, a device that can make all combinations? These are the issues that we must confront when thinking about AI and patents. The USPTO is seeking to work with stakeholders to address these issues. It has been presenting questions to the public for comments and is holding listening sessions to obtain insights, including the one that Allison referenced in the IP Law 360 article. We can see some of these questions that the USPTO has already presented may provide insight that will cause the USPTO to consider how it assesses obviousness for patent applications that use AI. For example, the questions they published on February 14, 2023 included: should the USPTO require applicants to provide an explanation of the contributions of an AI system made to the inventions claimed in the patent application? Or should contributions to inventions made by AI systems be treated differently from contributions made by other non-AI computer systems? It also asks what areas of focus, for example, obviousness, disclosure, data protection, should the USPTO prioritize in future engagements? This leaves us with the takeaway that much ambiguity exists with the protection that patents may provide to inventions created by AI or an applicant uses AI. Thus, it is important to take a holistic approach in which you look at the multiple methods of protecting AI. With that, Lori and Allison will provide insight into the other methods we can use to protect AI.
Yeah, thanks, Brian. Over in the realm of copyright, very conveniently for purposes of this webinar that we had slated some time ago for April, the United States Copyright Office just last month launched its new AI initiative. And for folks who have not checked it out, there's now an online webpage at the Copyright Office that collects guidance. It also identifies some upcoming dates for Copyright Office hosted listening sessions along the lines of what the PTO is doing. And then also in March, the Copyright Office issued a statement of policy offering new guidance on copyrightability and registration. Now, for anyone familiar with the fairly recent monkey selfie case, you will not be surprised to hear that based on the statement of policy, the touchstone for copyright surely remains human authorship. But that said, the March statement laid out emerging issues at the intersection of human involvement with AI and the availability of copyright in such instances, including in connection with the cancellation decision that is on this slide and was widely covered in the press involving a comic book. Importantly, the statement also has announced a notice of inquiry coming up later this year, in which the Copyright Office is going to address, among other things, and invite comment on copyrighted works used in AI training, so input side considerations. Now, outside of the Copyright Office, and there are cases that are emerging in the district courts. I've listed the one here that's probably furthest along, and this is a case that's currently pending in the United States District Court for the District of Columbia before Judge Howell. There are cross motions for summary judgment, briefing closed earlier this month. And the crux of the issue is the Copyright Office's denial of a registration over a two-dimensional piece of artwork purely generated by AI. So we're not in the realm of human involvement and parsing as in that cancellation decision, but the case focuses on the Copyright Office's decision-making for non-human authorship and deference due to the office. So stay tuned on that one. If I could have the next slide, please, to get into when copyright is the best choice to think about when considering different potential IP and contract possibilities. Anyone who is listening and is working closely in the software field will recognize the first bullet point as a familiar touchstone for consideration when looking to copyright. When there are instances where the company is disseminating software externally, particularly with high probability or possibility for reverse engineering, copyright is always in the conversation. The AI-specific components complicating the conversation and that evaluation today are what the Copyright Office described in its statement last month as works with sufficient human authorship. What do they mean by that? Well, there's at least two places to map that. One is on the input side. The Copyright Office has suggested appropriately that the prompts, in other words, what is fed into the AI in order to generate some sort of output, the prompts themselves can be the subject of copyright. And that makes sense, and depending on what industry you're working in and how much work is going into crafting those prompts, whether or not the prompts themselves rely heavily on proprietary data, that is going to be an increasingly important place to consider your potential for copyright. And then the Copyright Office has also mapped onto the output side the potential for copyrightability. What do we mean by that? Well, the graphic or the comic book cancellation provides good illustration, pun very much intended. On the human compilation side of AI output, in other words, the actual arrangement in that use case of images, the arrangement can be subject to copyright. That's a familiar concept in the realm of copyright with application here for AI outputs. The other piece of the conversation is about human modification. So what the Copyright Office has suggested would merit copyright are, quote, substantive edits to an intermediate output. So in other words, human involvement with the AI-generated output. Now, one thing that became clear through the statement that was issued in March is that disclosure is really the watchword for purposes of registration. And the Copyright Office has directed applicants to disclose the involvement of AI with works being submitted for registration. They have also strongly encouraged folks who have already secured copyrights that may have involved AI-generated material in some way, shape, or form to revisit their registrations, including effectively submitting revisions to those registrations. The perils of not following guidance here could include cancellation, as we saw with the graphic novel instance, although there's a caveat there, which is the Copyright Office canceled the original registration, but revisited it and allowed copyright registration on the compilation component and on the text that was authored by the human creator of that comic book. Also, for folks on the litigation front, there are going to be increasingly interesting questions. If a copyright registration was secured, there was not what comes to be deemed adequate disclosure, and there will be potentially implications for the viability of litigations if there was a non-compliant disclosure. To give you a quick sense of the scale of what this disclosure might mean in the copyright realm, Music Business Worldwide recently offered a podcast that touched on one single AI company doing work in the music space. And that one company self-reported that its platform had been used to co-create over 1 million songs. And maybe more interesting, the platform reported that 15% of artists using that platform identified as professionals in the music industry. So that's one narrow use case just from the music sector that suggests the scale of the issue that is currently at play. One point to be mindful of in terms of disclosure is to counterbalance against any sort of existing contractual requirements with regard to confidentiality, something to keep in mind.
Thanks, Allison. And with that, we'll transition to talking about trade secret. which can be a really powerful form of protection for components of AI, provided that adequate measures are taken to treat them as such. So specifically, each component can be protected provided that reasonable efforts are made to keep the information secret, and that the information derives independent economic value from not being generally known. Assuming these things are true, then trade secrets can offer may offer the best method of protection for components individually, because it allows protection in areas where patents or copyright may not, or for some reason you choose not to go with those approaches. For example, an algorithm by itself is likely only protectable as a trade secret. A unique collection of data is probably best protected by trade secrets, just as examples. So leveraging trade secret protection so pause a minute just to say, Allison, I think we'll talk about each of these a bit more. But leveraging trade secrets in these ways prevents the use of components by any third party that obtains the information by improper means. So of course, this would not be, as a little bit as Allison was talking about before, if there is dissemination of software in a commercial setting and then reverse engineering, that poses a bit of a problem. But with that, Allison, I believe you will speak a bit more about some of the pros and cons.
Yeah, and Lori, I'm sure this next slide looks familiar in terms of its considerations, not only to you, but others listening in. This tends to be the type of considerations that folks block out whenever they're considering trade secret protection, particularly over patents. I think we could map these onto non-AI use cases in many instances, but probably the on the pro-con list here, the top left is the point most complicated by AI, and that is that trade secrets avoid the barriers of patent protection. And Brian gave that really excellent run through many of the patentability issues that AI is now causing to be carefully considered. So there could indeed be unique strengths here that are amplified in terms of AI. And turning to the next slide, we thought to just remind everyone that trade secrets protection has real teeth. So these are not AI cases, but rather they are meant to be illustrative that there are real implications, and there's real protection available via the trade secret route. And like many AI instances that I am confident we will see in district courts, a lot of these types of cases in the existing realm involve employee departures, underlying breach of contract cases with joint partnerships and the like. So that's in addition to misappropriation. Those same causes of action are going to play out with the addition of AI to these assessments. So now that the litigator has pointed up some substantial damages awards, I'll hand it back to Lori.
Thanks, Allison. So because keeping the information secret is a prerequisite for protecting IP via trade secret, it's helpful to consider how you might go about this and where some of the biggest risks are of information disclosure that might pop up. So first and foremost, it is important to implement internal education and policies regarding the nature, importance, and treatment of IP. When trade secrets are exposed, it is most often through employees or ex-employees. So providing clear indicators for employees and contractors about what the company's trade secrets are and the policies regarding treatment of those trade secrets are really critical for reducing risks of exposure. And frankly, this can be inadvertent exposure or intentional, right? And so if it is made clear in this way to an employee what the company's expectations are and what the repercussions are for violating the policy, that is a powerful, or can be a powerful deterrent for anyone thinking that they can slip something through. Along similar lines, right, employee turnover might be a concern because an employee leaving the company might seek to take something with it or remember something and share it with a new employer. Especially important as we move towards a world in which non-competes are disfavored, right? In the US, federal actions more and more are showing this disfavor. Abroad, certainly in Europe and other jurisdictions outside the US, this is even more so. And so non-disclosure and invention assignment agreements with your employees, preferably signed upon hire, become more and more important so that you do have recourse should something happen. Also to consider if you're dealing with algorithms or technology and source code is that these are easily transferable. And so you need to think about policing access to these sensitive materials, preventing the copying to portable drives, implementing strong cyber policies, and data loss prevention too is a really important mechanism to at least alert the information security team when something is being moved around that shouldn't be. We also find that a clear open source policy and procedure for the use of open source is really helpful because otherwise you have eager developers pulling code from libraries where the legal team and others don't really know what the legal obligations are, and suddenly you wind up with an obligation to disclose your source code. Nobody wants that. And depending on the nature of your work, leveraging a third party who monitors the use of open source in your code might be really helpful. And finally, when you are engaging with third parties, contractors or collaborators, it's important to have detailed contracts regarding the governance and compliance around these matters, and sufficient oversight of how they're operating and how they're using your system. Ideally, a collaborator would use company equipment or be limited to being behind company firewalls, so that you retain control of what's going on and your own internal policies regarding security and DLP can be applied. And that's typically alongside strong contractual provisions. That's typically the best way to reduce the risk of disclosure in those situations. We can go to the next slide, where we are going to switch topics now, and I'll lead us through a conversation around contracts. So contracts are a really interesting tool in the AI world right now because they are the most flexible protection mechanism, especially where other areas of traditional IP remain unclear or unresolved, and where you want to be sure that you are most protected. So what can contracts protect against? Well, all components of AI, really. The perhaps downside is that the protection is limited to the parties that are subject to the contract and perhaps subsidiaries or affiliates or third parties that are included, but it is a more limited scope of protection in that regard. And the beauty of a contract is that you can discuss all manner of ways in which you do or don't want the AI to be used, questions of ownership, rights, and how it all can be used going forward can all be clearly and fully outlined in the contract. Next slide. So it is really important when you are contracting around an AI component to take the time to understand all of the inputs and outputs. In order to achieve the robust protection you want, it is critical to develop a full understanding of the engagement at hand. And most often this starts with a simple question, is this a service provider model or is it a collaborative venture? This informs the rest of the questions and the rest of the scope of the agreement. And on each side here, you'll see a variety of questions that are important to ask in each case. And then from there, you develop a fuller picture of what the engagement looks like. If this is a traditional service provider model with sale or license of a technology, product, or service to a customer, here you're going to be, the questions you want to be asking are first to your internal team, but also to the other side, to the customer. Because assuming for a second that you are the provider of the AI component, you of course want to understand your own offering, so that you can develop your template or your standard provision around how you expect your offering to be used and protected. But you also want to understand how the customer intends to use it in detail, and then memorialize that in the contract with limitation on use provisions. This is really important because innovation in this area is rapid, so it is impossible to anticipate all the ways that a customer might want to or end up using your tool or your component that contains AI. So asking the detailed questions up front allows you to identify the areas that are off limits, or perhaps maybe it's a different fee arrangement, right? If you recognize that your customer wants to use your product or your offering in some new way, that's valuable. And then so maybe that's a different price tier or something like that. But asking these questions and developing this full understanding really allows you to have that conversation with your internal team so that you're prepared for how it will be used going forward, and you're making sure that you're protected and you're deriving the value from it that you should. This also hopefully removes ambiguity and might save some conflict down the road when suddenly you realize your customer has been using your component of AI to insert any manner of possibilities here that you hadn't anticipated. When you're partnering or collaborating on development involving AI, many of the questions and the issues are the same, but you'll be even more concerned about the results of the collaboration, who owns what, who has a right to do what with the outcome, et cetera. So a lot more questions here in that regard. And it's also really important to consider how the parties will share potential liabilities arising from AI-generated outcomes. Again, this can be any manner of issue that might come up from use of a model that has, a molecule that has involved some component of AI and is now made its way into a drug, and there's all manner of things that might happen there, or a data set that is now in use and oops, it contains some PHI or any manner of things like that. Coming to agreement on how those liabilities might be treated up front will save you a lot of headache in the end. In the last note here on this slide, I'll just say that even if your offering contains no AI components, you still want to know how the customer or partner will be using your offering, because it may be extremely valuable to the AI tools being used by the other side, right? So you may have a data set that was compiled without the use of AI at all, but that data set is really valuable to an AI tool who wants to train and learn, right? And so that's a simple example. There are many, but therefore you may want to restrict the use or again, price accordingly for the privilege to be able to do what your other side is looking to do with your non-AI tool. Next slide, please. So the top of mind questions for any engagement where AI is involved will naturally be, what rights will the parties have in the various components contributed or that result from the contracted engagement? And this is where contracting can really shine as a protection mechanism, because it can really be whatever the parties negotiate and agree with, as long as you are developing that full picture I previously talked about, your product, the other side's product, and how they're going to be working together. So when thinking about algorithms and trained models, the ownership of algorithms is likely to stay with the party supplying the algorithm, but the training model is a result of the algorithms along with other things, data sets, use cases, et cetera. And so here the questions pop up, right? And you see a list of contract provisions there that are critical to defining each party's rights and how it will be allowed to be used and how you will govern the relationship, the use going forward. Audit rights are important, or perhaps reporting from one party or the other on how things are being used. It can be pretty critical in making sure that your expectations are met and your component or your contribution is not being used in ways you didn't anticipate, or you're losing out on value from your contribution. And we can go to the next slide. When thinking about rights and permissions regarding data sets, protective contracts clearly will address in detail, of course, which entity owns the input data and the output data. Questions of ownership around improvements or changes to a data set over the life of the project. So, perhaps it's not a final output or a new data set that results, but we spoke about before, data sets used to train certain AI tools. So where's the ownership there, and how does that play out? Ownership questions regarding derivatives of the data set. So a little bit more like in that vein. And then how parties will treat intellectual property and outputs generated by multiple inputs. So if you're each making contributions, how does each party view the output, and what rights will you have to it to be able to use it, own it, etc. Of course, will be critically important, and you'll want to make sure that that's very, very clear in the contract so that everybody has a clear path forward and can hopefully save conflicts later on. And so with that, I believe we've reached the end of the main presentation. Yeah, I believe we have some time for questions. If anybody has some, feel free to pop them in the chat, and we're happy to answer as well as we can.
Well, thank you, Lori, for that in-depth discussion of contracts, which I must say, even from our own personal experience, many of the transactions that we're asked to advise upon, all of them, be it high tech or even in the life science space, so many of these are touching on AI issues. And particularly the issues that you just discussed, in the fact that, some people that have the algorithms or the model just want to say, just give us all the data. We're not going to disclose to you the algorithms or the model. We don't want you to know that. We'll use your data, and then we will take that and we will, give you the results. And maybe in the life sciences space, they're saying, we'll identify all the molecules that will come up and you could go and test that. But the balance to that is the access that maybe the life sciences company gave them to these years and years of data that will have changed that model, will have improved that model. And it's important to then say what you can do with that model afterwards, because you don't want that AI provider then go take it to your competitor in the exact same space. So contracting right now, and as you laid out, is tremendously important. So thank you for that insight. And Allison, also thank you with the way that you're talking about even just the prompts, for how that's a kind of an innovative way to maybe think about copyright in such a way that you may be able to cover those prompts, because as we had discussed earlier and you so nicely laid out, those individual prompts, when fed into different AI systems, may give you completely different results. So I think your involvement and your suggestions here have been really on point and really up to date. So thank you for all of that. So I think I don't see many other questions out there at the moment, but I'd like to pass it over to both Lori and Allison to give some final thoughts on their topics.
Well, I have a question I've been frequently receiving, including today, and it kind of is a riff, Lori, into a different type of work and industry from your excellent point about really, and particularly with business partnerships, understanding the collaboration, its contours, and doing your best to be nimble in addressing the future use cases that you can't quite predict. And one from the realm of book publishing, I don't know how many folks who are joining us might have the instance of a CEO or another leader in the company writing a book, and often there's a collaboration with a ghostwriter in these instances. One use case that comes up, and probably in an unexpected way, is, is there an AI being involved for purposes of ghostwriting? And maybe the other signatory to the contract is unaware of that. But typically in these instances, the copyright effectively is going to be preordained to be residing with the publicized author. That presents a really interesting question if there was an AI that was unknown to the author of the book that was involved in generating the text in the book. So that we just see myriad use cases across industries where, to Lori's great point, it's when you're in the position, it's a collaboration from the go. You're in a position to assess issues that could arise. Those questions that you presented, Lori, are really good for that thought exercise, and they're important to undertake.
Yeah, absolutely. As you say, it is and will continue to be widely applicable, really, in anything we're doing today, I think, business-wise or otherwise. And yeah, what I have found is in any case, as an in-house lawyer, contracting lawyer, right, it's always important to fully understand whatever the engagement is, right, to spend time with the various teams involved and go in depth and really understand. That's the best way to write the best contract for your situation. It just strikes me as incredibly more important when we're talking about AI, because there are so many unknowns, because it is the heart of innovation today. There are all of these new ways that it's popping up that we don't even know until it's news. And then, as you say, Allison, ghostwriting a book or creating a piece of music or a piece of art, right? It's sort of an invisible piece. So being as close as you can to it and really having those in-depth conversations with the relevant teams around what's happening and what's the expectation and how it will be used, become even more important.
Well, I think we're coming to a close here. First, I'd really like to extend my gratitude towards you, Lori. I know you've taken your evening out now that you sit in Europe as the head of global business operations, and also for you to bring both the business perspective as head of business operations coupled with your former expertise as general counsel. So it was really insightful. So thank you. And as always, Allison, it's always a pleasure when I get to partner with you and work with you on these interesting subjects. So, but I think with that, we're coming to the close of the presentation. I hope you found this to be helpful and useful. And I reiterate Allison's presentation right at the beginning is if we didn't touch on a topic or if there's industry specific questions, please feel free to reach out to us or suggest how we can expand upon or improve this material in this presentation.